My ladies, my lords, in this appeal I act for the appellants, together with my learned friend Mr. Bunting, the respondents represented by my learned friends Mr. Mabley, leading my learned friend Mr. Pawson-Pounds. My ladies, my lords, this case arises from a demonstration held in London in January 2018 about events in northern Syria, an area with a large Kurdish population. Many of the placards on an uncontroversially lawful, save for the matter that brings us here today, many of the placards were entirely legally unobjectionable, but a number of the placards were said by expert witnesses to espouse support for the PKK, a proscribed organisation. Forgive me, I'm entirely in the court's hands if my lady would like me to pause while a technological issue is resolved.
Thank you.
My lady. My ladies, my lords, there was no suggestion the demonstration was turning violent. There was no suggestion the demonstration was in danger of provoking violence from bystanders. There was no suggestion of a rival group about to engage in violence on the demonstration. We will say, in due course, that has a relevance to the second of our two arguments, whether the prosecution and conviction of these appellants was permissible under Article 10 of the Convention. As the court knows, the three appellants were then prosecuted and convicted for an offence under Section 13 of the Terrorism Act 2000 on the basis that the placards they held. They appealed, and in the Crown Court and in due course the Divisional Court, it was said, firstly, that the Section 13 of the Act does not require a mens rea, and secondly, that prosecution of these appellants under that section was not a violation of Article 10 of the European Convention. We say, with great respect to all the various judges involved, those conclusions are wrong in law, and had those errors not been made, all three appellants could, our first argument, or should, our second argument, have been acquitted. My ladies, my lord, there are the two strands to our argument. They are set out in great detail, of course, in our written case. I hope the most useful approach is for me to go to the various sections, what we say are the most important cases, but of course, if there are matters the court feels I need to address or I'm failing to address, then I'm ready to do my humble best to meet any such failings.
Could I just ask, you used the word placard. I'd assumed it was a flag, but is that incorrect?
It's a flag. My lord's right and I'm wrong. Perhaps we should start by going to Section 13 of the Act. In electronic pagination terms, the Act starts at page 277, and Section 13, the court will, I hope, find at page 301. My ladies, my lord, Section 13, uniform. A person in a public place commits an offence if he wears an item of clothing or wears, carries or displays an article in such a way or in such circumstances as to arouse reasonable suspicion that he is a member or supporter of a proscribed organisation. While we're on this page, as it were, the court will see there is subsection 1A that was inserted to be effective from the 12th of April 2019. The date indeed is at the top of this page. We say that does not have a significance. It's one of the arguments raised in the courts below, because although Parliament did add to this section without specifying a mens rea was required, the court will of course appreciate that the date of the passage of the legislation to amend section 13 was before the divisional court pronounced judgment in the case which is now before this court. And thus we say it is not a safe basis to say that Parliament, aware there was no mens rea, happily added to that section without imposing one. Can we start, please, by going to the obvious starting place, the case of Sweet and Parsley? It's at page 503 in the electronic bundle. Forgive me, none of the court are working, I think, from hard bundles, so
that's right. We don't.
I will simply
there
use
aren't any hard bundles. We're working on the electronic bundle.
My Lord is many decades ahead of me. I have paper copies, but if anyone ever wants a tab number, I see my learned friends back in the last century with me. It's tab 7, of course, of our first bundle. The case of Sweet and Parsley, a case from the 60s. The court will be very familiar with it. If we start, please, at page 503, just to remind the court, if I may, of the terms of the section 5 of the 1965 Dangerous Drugs Act. If a person, and we go to subparagraph B, if we may, for these purposes, is concerned in the management of any premises used for any such purpose as aforesaid, smoking cannabis resin in this case, he shall be guilty of an offence against this Act. Within the speeches in Sweet and Parsley, and I take the liberty in all these cases of not dwelling on the facts in more detail unless the court would like me to, if the court would go, please, to electronic page 519, 519, internal numbering of Sweet and Parsley in the Lords 148 at F. We have the speech, we have a speech later to be referred to as magisterial in the case of B and DPP by Lord Nichols, and we have the articulation by Lord Reed at G, which I will pick up, if I may, on page 148, internal numbering, 519, electronic. In a very large, and this is about 7 lines up from the bottom of the page, please, in a very large number of cases, there is no clear indication either way, in the words of a statute, whether there is or is not a mens rea. There is no clear indication either way. In such cases, there has for centuries been a presumption that Parliament did not intend to make criminals of persons who were in no way blameworthy in what they did. That means that whenever a section is silent as to mens rea, there is a presumption that, in order to give effect to the will of Parliament, we must read in words appropriate to require mens rea. And over the page, or on the next page, please, finishing off where it's contended an absolute offence has been created, the words of Baron Alderson in Attorney General and Lockwood have often been quoted. The rule of law, I take it, upon the construction of all statutes, and therefore applicable to the construction of this, is whether they will be penal or remedial, to construe them according to the plain, literal, grammatical meaning of the words in which they're expressed, unless that construction leads to a plain and clear contradiction of the apparent purpose of the Act or some palpable and evident absurdity. Lord Reed continued, that is perfectly right as a general rule, and where there is no legal presumption. But what about the multitude of criminal enactments where the words of the Act simply make it an offence to do certain things, but where everyone agrees there cannot be a conviction without proof of mens rea in some form? This passage, Baron Alderson's passage obviously, this passage, if applied to the present problem, would mean there is no need to prove mens rea unless it would be, quote, a plain and clear contradiction of the apparent purpose of the Act to convict without proof of mens rea. But that will be putting the presumption the wrong way round, for it is firmly established by a host of authorities that mens rea is an essential ingredient of every offence, unless some reason can be found for holding it's not necessary. Forgive me, I will not read it all out, but just this is perhaps the second of the two key pages upon which the first limb of our argument is founded, so I continue at D. It's also firmly established that the fact that other sections of the Act expressly require mens rea, for example, because they contain the word knowingly, is not in itself sufficient to justify a decision that a section which is silent as to mens rea creates an absolute offence in the absence of a clear indication in the Act that an offence is intended to be an absolute offence. It's necessary to go outside the Act, examine all relevant circumstances in order to establish this must, my emphasis of course, this must have been the intention of Parliament. I say, quote, must have been, unquote, because it is a universal principle that if a penal provision is reasonably capable of two interpretations, that interpretation which is most favourable to the accused must be adopted. And then picking it up at F, if we may, Lord Reid deals with the well-known case of Sheres and Derutson, elsewhere in the papers in this appeal, and says of the decision of Mr. Justice Wright in that question, picking it up at F, please, but he was there dealing with something which was one of a class of acts which are, quote, are not criminal in any real sense, but are acts which in the public interest are prohibited under a penalty. And then slightly lower down the page, it's long been the practice to recognise absolute offences in this class of quasi-criminal acts, and one can safely assume that when Parliament is passing new legislation dealing with this class of offences, its silence as to mens rea means the old practice has to apply. But when one comes to acts of a truly criminal character, it appears to me there are at least two factors which any reasonable legislator will have in mind. In the first place, a stigma still attaches to any person convicted of a truly criminal offence, and the more serious or disgraceful the offence, the greater the stigma. My lords, my lady, here we are dealing with three young men who for many people will henceforth be branded as terrorists because of the criminal conviction they have acquired at the early stages of this litigation. To continue with Lord Reid, if we may, 3 lines up. So he would have to consider whether in a case of this gravity, the public interest really requires that an innocent person should be prevented from proving his innocence in order that fewer guilty men may escape. My ladies, my lord, at page 150, forgive me, electronic 521, Lord Reid at B then suggests that it is not, my words, not his, binary, in that it is not a choice necessarily between a full-blown mens rea for every aspect of every offence, or whether on occasions the courts could not have the halfway house of recklessness or imposing an evidential burden to raise a defence. That comes with the caveat at F on that page, please. So F, electronic page 521. Lord Reid went on to say, it may be that none of these methods is wholly satisfactory, but at least the public scandal of convicting on a serious charge persons who are in no way blameworthy would be avoided. And that is all I wish to take the court to from Sweet and Parsley. Could we look at one more case establishing this proposition, and then I'll deal with two more authorities on this point. Could we go next, please, to B and the Director of Public Prosecutions. It's at page 392 in the electronic system. My lords, an appeal from the late 1990s. The facts have a relevance. The headnote gives us those in a couple of sentences at 392, please. A 13-year-old girl was on a bus. The defendant, who was 15, sat next to her and asked her several times to perform oral sex with him, which she refused to do. He was charged with inciting a girl under the age of 14 to commit an act of gross indecency contrary to Section 1 of the Indecency with Children Act. He pleaded not guilty. It was accepted he'd honestly believed the girl was over the age of 14 and thus out with the terms of Section 1. But the justices ruled there was no mens rea defence. This law report starts, of course, with the Court of Appeal's decision, and although it is overturned by the House of Lords in due course, might we just look at one paragraph of that? If the court would go to 396, electronic 396, please, just to see what it is we are considering. 396, it starts with the judgment of Mr. Justice Rougier. Pausing for the sort of comment that those of us had the pleasure of appearing in front of Mr. Justice Rougier will remember, a debate about what a shiner meant in his youth. He then goes to the foot of the page and sets out the subsection, and his conclusion, overturned by the Lords, of course, but I draw attention to it because this is a line of argument the respondent advances in this case. His conclusion is based upon the reasoning at page 404. Electronically, please. 440 in the numbered reports. 404 electronically. And at G, Mr. Justice Rougier said, to my mind, the inclusion of the specific statutory defence in the two sections which I have mentioned demonstrates conclusively that Parliament did not intend that defence to be available to those other offences where there is no such provision. For instance, the comparison between the terms of Section 5 and 6 is, to my mind, is deadly. Now, that is an argument relied on extensively in this appeal, and that's why I draw attention with respect to Mr. Justice Rougier arriving at what their lordships was to say was the wrong decision. If we could go to the speeches of the House of Lords, please, starting at electronic 427. 427, please. Lord Nichol's speech. At H, in Section 1 of the 1960 Act, Parliament has not expressly negatived the need for a mental element in respect of the age element. The question, therefore, is whether, although not expressly negatived, the need for a mental element is negative by necessary implication. And in this sentence, of course, we place weight upon necessary implication connotes an implication which is compellingly clear. Compellingly clear. Such an implication may be found in the language used, the nature of the offence, the mischief sought to be prevented, and any other circumstances which may assist in determining what intention is properly to be attributed to Parliament. If my lords would, and my ladies, forgive me, would pick up the same page, 428 at F. Lord Nichols continues, nor can I attach much weight to a fear that it may be difficult sometimes for the prosecution to prove the defendant knew the child was under 14 or was recklessly indifferent. A well-known passage from the judgment of that great jurist Sir Owen Dixon in Thomas and the King, 1937, bears repetition. The truth appears to be that a reluctance on the parts of the courts has repeatedly appeared to allow a prisoner to avail himself of a defence depending simply on his own state of knowledge and belief. The reluctance is due in great measure, if not entirely, to a mistrust of the tribunal of fact, the jury. Though through a feeling that if the law allows such defence to be submitted to the jury, prisoners may too readily escape by deposing to conditions of mind and describing source of information, etc. And judges of matters upon which the evidence cannot be adequately tested and contradicted, judges have been misled into a failure steadily to adhere to principle. It's not difficult to understand such tendencies, but a lack of confidence in the ability of a tribunal correctly to estimate evidence of states of mind and the like can never be a sufficient ground for excluding from inquiry the most fundamental element in a rational and humane criminal code. And finally, from Lord Nichols, if we may please, at 429, further down the same page. his lordship deals with the argument that Mr. Justice Rougier accepted the comparison of different sections and the fact there were explicit mens reas in other sections. 5 lines up from the bottom of 429, please. Where the Crown's argument breaks down is that the motley collection of offences of diverse origins gathered into the Act of 1956 displays no satisfactory, clear or coherent pattern. And as we are on this judgment, may we look briefly at the speech of Lord Steyne at 434, please. 434. Under a passage headed "The Correct Approach," his lordship at B says this: "In enacting such a provision, Parliament does not write on a blank sheet. The sovereignty of Parliament is the paramount principle of our Constitution, but Parliament legislates against the background of the principle of legality." And his lordship discusses legality and then quotes Professor Sir Rupert Cross further down the page. Just to touch on that, if we may, at F on electronic page 434. Sir Rupert explained that such presumptions are of general application and are not dependent on finding ambiguity in the text. He said they, quote, "not only supplement the text, they operate at a higher level as expressions of fundamental principles governing both civil liberties and the relations between Parliament, the executive and the courts. They operate as constitutional principles which are not easily displaced by statutory text." There are other passages to similar effect, but I know the court will be very familiar with this terrain and they are set out in our written submissions, so I will move on if I may. I will come to Lane and Letts. Lane and Letts, a decision, of course, of this court, which the respondent placed significant weight upon. But before doing so, I would take, my ladies and my lord, if I may, to the case of O'Moran and Whelan. That is at tab 35, which, forgive me, is no use to the court. It is at page 997, please. 997, electronic bundle. This is not a case on point, which perhaps may not be a promising start to submissions deploying it, but nonetheless we say there is a value in considering it briefly. O'Moran and the DPP heard together with Whelan and the DPP. It was about the predecessor of the section we are considering, and the case focused on the meaning of uniform or uniforms. A court made up of the Chief Justice of the day, Lord Widgery, with him Melford Stevens and Mr. Justice Watkins, as he then was. So a formidable tribunal if one considers experience of the criminal law. Just to understand which of the 2 cases we are considering, if the court would be so kind as to go to page 1001, please. 1001. We see the second case is Whelan. And then still in the recitation of the facts, please, which has the relevance I'll come to in a moment, if the court will go to page 1003. These are about protests which gave the impression they were supporting the IRA. But page 1003 at G, the history includes the magistrate was of the opinion that whether or not a particular dress amounts to a uniform was a question of fact. That's the issue in the case. But then at the bottom of that page, please, this is the magistrate's decision, 4 lines up. Similarly, he should discharge another accused because, although he was satisfied he was wearing a black beret to march and distributing IRA badges, he accepted his evidence that he wore a black beret as his usual headdress and had not adopted it for that occasion in order to signify his association with the provisional Sinn Féin. And if we turn, if we may, to the judgment of Lord Widgery, At electronic 1008, please. 1008G, just to show that Lord Widgery then turns to consider the second case.
Could you just help me?
I'm sorry, my Lord.
The internal numbering of...
The internal numbering is 875, my Lord.
Thank you, letter G. Thank you very much.
My Lord, having troubled my Lord to go there, it's simply to show that this is the second of the two cases that Lord Widgery is discussing. And the only sentence I want to take the court to, having established that, is at internal numbering 876, electronic 1009, please. Lord Widgery at F. Citing the conclusion of the magistrate on the point under appeal, I concede at once, but Lord Widgery at F said, I'm entirely in agreement with what the magistrate said. Now, as I say, we concede at once, that is Lord Widgery addressing the magistrate on the matter under appeal. But the court was clearly apprised of the decision of a stipendiary magistrate dealing with the predecessor to this section who had acquitted someone on the basis of mens rea. It was not their intent in dressing up in a certain manner to give the impression that otherwise led to convictions.
So you read that as him agreeing with everything that the magistrate did, not just the opinion expressed in the quote above?
No, my lady, I'm not quite so bold. I make a broader submission, which is this. May I backtrack before trying to answer my lady's question in this way? The respondent's argument proceeds on the basis that hitherto this section has always been understood as having no mens rea. The reason we go to this passage is to show, perhaps in increasing order of importance, firstly, a stipendiary magistrate was adjudicating on cases assuming there was a mens rea, and secondly, that a very strong court, certainly in terms of the experience of criminal law, knowing the facts, including that acquittal by the magistrate, at no stage criticises or picks up on or comments that the magistrate was applying too generous a test. It is simply this, my lady, if it is to be said, as it is said, and was said by the Divisional Court, that Parliament amending Section 13 by inserting Section 13(1)A, Parliament knew full well that Section 13 had no mens rea and then amended that section without troubling to impose a mens rea, then we say there is simply no clear line of authority establishing that that was the understanding, and thus that is not a statutory interpretive inference open to the respondent and thus, of course, to the court.
If you look at how the Chief Justice addressed the actual issue before them, at page 1007, internal page 874, he was looking at photographs of what had happened in Quecks Road.
Lady, yes, at G, I see on that page,
yes.
1007.
And he says if you look at the pictures, at the picture presented outside the church that morning, you would find these men in a uniform which associated them with the other activities then going on. If one examined what those activities were, it would become abundantly clear they were activities of a political character. Thus, the chain of responsibility under this section would be complete. He doesn't there seem to be looking beyond what somebody attending the scene would see to considering the intention or the mens rea of the people in the photograph, does he?
With great respect, of course, I entirely take my lady's point. It all comes with the health warning. The issue in this appeal is not the issue being discussed in that appeal. But, my lady, it is very common, of course, to have criminal offences. And if one thinks back to Lord Reed's, ruminations is too disrespectful, but Lord Reed's discussion in his speech in Sweet and Parsley about whether there can be an evidential defence that is raised. Well, that sentence by Lord Widgery is entirely consistent with saying, for example, once that impression will be given to the public, the causation is complete, but the magistrate was not wrong to go on to say, That having been established, I then heard evidence from a defendant who was able to say, that was not my intention, that was not my state of mind, and then acquit them. And as we're on the topic of defendant's evidence, may I simply, in passing, pick up one thing said in the divisional court, that the judgment from which we now appeal. In the divisional court, it was said, it was simply noted, without any particular significance being attached, that the defendants in the Crown Court, having had the adverse ruling as to mens rea and Article 10, had not then given evidence. Well, rhetorically, I pose the question, given where I'm standing, rhetorically I pose the question, what would the point have been on the understanding of the law that the Crown Court had laid down? There was no issue for them to give evidence about. Going on next, if I may, to the case of Lane and Letts.
Just before you do,
I'm sorry, my lord.
Are you saying that Mr. Nichols' opinion, quoted at 1009, is about mens rea?
My lady, forgive me, I had attempted to move on. The fault is mine, 1009.
When you say...
Oh, forgive me, no, my lady, no. The paragraph that Lord Widgery is specifically approving is on a different topic. It's about what is the issue in the appeal. It is merely Lord Widgery approving of the point on appeal, but not, as the Divisional Court is entirely capable of, not pausing to point out that on a basic fact that's led to an acquittal in what was not a complicated case, that the Divisional Court thought the magistrate was wrong to acquit.
Yes, we are speculating a bit, aren't we?
We are speculating if I try to retrospectively read the mind of Lord Widgery to establish specific approval. However, here we have a law report in which the law had been applied with a mens rea, and therefore we do say it is not safe terrain, with great respect to the court, it's not safe terrain to assume that Parliament, in amending Section 13, thought there was a final, settled, undebatable position that no mens rea was required by that section. May I go to Lane and Letts, please, a case on which great reliance has been placed by the Respondent and indeed the Divisional Court. It is at electronic page 483. It is divider 5 for those of us with paper. Lane and Letts, of course, a decision of this court. The judgment given by Lord Hughes, with whom the rest of the court agreed, and I'm conscious that the Court of Appeal decision was a court presided over by Lord Justice Lloyd Jones, as my Lord then was. We don't disagree. Even my Lord had not presided. We wouldn't disagree with the conclusion in Lane and Letts. Can we go to the offence under discussion, please, at 485 electronically? And indeed, my learned friend Mr. Mabley was successfully resisting the appeal. 485 is the offence. Section 17 of funding arrangements under the Terrorism Act 2000. A person commits an offence if he A, enters into or becomes concerned in an arrangement as a result of which money or other property is made available or is to be made available to another, and B, he knows or has reasonable cause to suspect that it will or may be used for the purposes of terrorism. And the question raised on this, I think, pre-trial appeal at paragraph 4 is this is set out at paragraph 4 on electronic 485. The question which arises concerns the correct meaning of the expression has reasonable cause to suspect in section 17b. Does it mean the accused must actually suspect and for reasonable cause, or is it sufficient that the information known to him there exists, assessed objectively, provides a reasonable cause to suspect? And the court then looks at, starts, of course, with the speech of Lord Reed in Sweet and Parsley. That's at 486. And then, if we go, please, to 487, we have the passage from Lord Hughes which is, sorry, other document, excuse me. We have the passage from Lord Hughes, which is relied upon both by the respondent and by the divisional court in this case. If one picks it up, please, at paragraph 9 on page 487, having rehearsed Lord Reed's speech in Sweet and Parsley, Lord Hughes goes on at 9, while the principle is not in doubt and is of great importance in the approach to the construction of criminal statutes, it remains a principle of statutory construction. Now, in the hands of my learned friends, Skeleton to the divisional court, this leads them to describe Sweet and Parsley as a principle of statutory construction and no more, unquote. Well, we do say, with great respect, of course, we do say that these are the dangers of a single sentence in a decision of any court, including, with very great respect, this court. The dangers are that a single sentence, or indeed part of a single sentence, in this particular example, is taken, the surrounding discussion is not quoted, and it is put forward as if it was the words of a statute. It is our respectful submission that Lord Hughes in no way is seeking to cast doubt on the profundity of the principle, the high principle, the constitutional principle, as it's been described in other cases. At no stage does Lord Hughes suggest he is casting doubt or changing the law. He is merely saying it's not the final answer in all cases. And the reasoning of the court in this particular case, in essence, the court has little difficulty, not belittling my learned friends' arguing abilities, but has little difficulty for two reasons in saying the court does not have to reinterpret this section of the 2000 Act. Firstly, because there is a mens rea, it's set out in terms, and that is at, the court doesn't need to turn it up for my purposes. Paragraph 13 of this judgment, Lord Hughes points out there is a mens rea. And secondly, and this is from paragraph 18, Lord Hughes makes the point that there's been an amendment to specifically insert a new and lesser mens rea. The amendment of the statute has changed. The predecessor offence said knowing or suspecting. This is all at paragraph 18 and 19. Knowing or suspecting, and then Parliament changes that, knowing or having reasonable cause to suspect. So there really is no reason to debate that but that the statutory history has made the difference.
Just before you leave that, going back to paragraph 9, is there anything in that paragraph that you're disagreeing with? I mean, it is a principle of statutory interpretation.
It is, of course, with great respect. We're interpreting a statute. Here we are, relying on this principle. But it is the attempt to use that sentence to downgrade it, to say it's of less significance than a great, long, consistent body of authority has said. So no, we don't, but it has to be read in a proper context against the proper history.
Thank you.
And without adding the words "and no more," without being overly fastidious on the language used by the respondent. My lords, my ladies, we set out in our written case what we say are the application of the principles that I have attempted to rehearse and that we rehearse more exhaustively in our written case. I won't take the court to it unless the court would particularly like to be taken to it, but the obvious features are Section 13 is silent as to mens rea. It does not have different mens rea as in lane or lets. Section 13 has not been amended from an earlier version which had a mens rea, again like lane and lets. There is no history of the interplay of legislation and decisions of the appellate courts, as in the Northern Irish case of Brown, which makes absolutely clear Parliament has intervened to, in two sections, add a mens rea defence and has left Section 4 in that particular example untouched. This is a serious criminal offence. The punishment is not of a particularly serious nature, but the effect is to leave someone with a conviction for an offence under the Terrorism Act, which will make future employment somewhere between difficult and well-nigh impossible, will have an effect on the ability to travel, on all aspects of life where previous convictions or previous recent convictions or convictions of a certain severity need to be declared. This is a profound and scarring event in these young men's life. We say, with great respect, against the background of principles, it is inconceivable that Parliament as a whole intended this should be imposed on people who did not realise they were committing an offence. There's been a great deal of debate with examples we advanced in the lower court, whether a certain illustration, a hypothetical example is realistic or unrealistic. Someone present who is blind, or a policeman in plain clothes carrying exhibits. There's perhaps a simpler example. If there is a demonstration about events abroad, quite common, if there are placards, unlike this demonstration, I'm grateful for the correction, which have things written on them in support of a proscribed organisation, and if someone attending that demonstration, whose body in the United Kingdom but whose roots are elsewhere, who cannot read English, joins in the demonstration and picks up a placard, well, that person, if the placard they happen to pick up supports a proscribed organisation, that person, under the law as described by the Divisional Court, would be guilty of an offence under the Terrorism Act 2000. Now, we say that simply, with great respect, cannot be right, and we say it is not the law.
A policeman carrying away a placard or a flag as evidence wouldn't be performing the deliberate act of displaying it.
Well, if the court, and my Lord, I anticipate, possibly wrongly, my Lord has in mind some of the other cases where the words that are used in the section are analysed so as to import an element of mens rea. In Sweet and Parsley, for example, there is, I think, managing. A route that the court could find, with great respect, would be to say displaying includes within it at least a knowledge as to the nature or an intent to display that which is on display. There could be ways in which a display could be interpreted so as to import a mens rea.
I had in mind a rather different point, I think, and as I understand it, it's accepted by the Crown, there is a requirement of a deliberate act, of, for example, perhaps it's a better example, of wearing an insignia. There has to be an intention to actually wear it.
Well, my Lord, that's right, and one can construct hypothetical examples at length. A policeman carrying away a placard, knowing it's a bright sunny day and he's holding it the right way up, could be seen as displaying it. If the focus is on the intention, the perception of the reasonable bystander, then on the stark mens rea free reading of the section, why would that police officer not be displaying it? It may not be his intention to display it, but yet he is doing exactly the same as a demonstrator stood 5 yards away who's holding the same placard the same way up, wearing the same civilian clothing.
What about someone who has a flag or an insignia attached to his back without being aware of it?
If someone passing by, a police officer, pats them on the back with a PKK sticker,
yes,
then, my Lord, I think there would be a defence, because the reasonable observer would think there is a policeman with a sticker on his back. But my Lord...
But there wouldn't be a deliberate act of wearing or displaying.
We would not say that was caught by the section. But, my Lord, the example we give, because it seems to us to be not a million miles, at least, from the facts of the instant case, is what about a foreign national with imperfect English who picks up, in the example I give, it's a placard, so it has this tweak on the facts, picks up a placard, knows he wants to protest about alleged war crimes in northern Syria, picks up a placard, and he picks up the wrong one, and he can't read English. That person, could it really be said that person deserves to be convicted of Section 13 of a terrorism offence under the 2000 Act? That's how we put the argument, my Lord.
It's going to help me at some stage, I don't know whether you want to come to it now, to know what your precise formulation of the mens rea would be. I don't want to take you out of your order, You're starting to give us hypothetical examples, and I need to know, I think, I mean, it's already in the answer to my Lord Jones. I don't think there's much dispute that there at least has to be, in the example we're talking about, an intention to carry a flag. You've got to know that you're actually carrying a flag. But clearly that's not what we're talking about. That sort of deliberate act is obviously not the issue in the case.
My Lord, I'm happy to try to deal with it now. My Lord will obviously judge if I'm able to do so. Our primary answer, which may seem like in a way of avoiding the question for good reason, but our primary answer is we say there needs to be some mens rea so people cannot inadvertently become labelled as terrorists, and that whichever formula the court thinks best is the one that should be adopted. But the sort of thing one could add, if one inserts the word knowingly, so it becomes carry or display an article in such a way as to knowingly arouse reasonable suspicion that he is a member or supporter of a proscribed organisation, that would meet the complaint that we make.
That's the primary way in which you put it.
My Lord, it is, with the caveat that our essential complaint is that someone who does not know what... My Lord has the point. Our primary complaint is that an innocent person should not end up being convicted of a Terrorism Act offence.
Yes. Reading your written case, I had it in mind that you say that there's a requirement of an intention to show support for a proscribed organisation. Is that right?
That is certainly one of the formulations that could be adopted to solve what we say is an obvious problem.
So this is not a single case that you're advancing. There are various possible mens rea.
My Lord, there are, and of course the other point that can be made about the formulation that we suggest at one stage in our written arguments, my Lord's just reminded me of, is that it becomes, at least, it overlaps very heavily with other neighbouring sections, as it were.
If we're speaking about the intention of the legislature,
yes,
doesn't there need to be a single intention?
Forgive me.
Doesn't there need to be a single intention if we're speaking about the intention of the legislature?
Well, forgive me. The intention of the legislator, we say, is illustrated and made clear by the non-blank sheet against which they write. If my Lord means the intention of the offender...
we're seeking to ascertain whether there is a requirement of mens rea. As I understand it, you're saying, well, there are various possible mental elements which could be ascribed to this provision.
My Lord, yes.
And if we address it, there may be objections to this approach, but if we address it in terms of seeking to ascertain the intention of Parliament, the intention of the legislator, can there be more than one intention?
Well, my Lord, there may only be one intention, but how one finds... There are perhaps two steps. One is it free of mens rea or is there a mens rea? Secondly, if one gets to the second step, as we of course say, my ladies and my lord should, how should one interpret and define what Parliament's intention was? Now there we would refer back to Lord Reid's discussion in Sweet and Parsley about a variety of ways to resolve this, whether it be an evidential burden to show that was not the intention, or whether one simply, in the formulation I just suggested to my Lord, simply puts knowingly in at that part. But our fundamental argument is there may be a number of answers, but our fundamental submission is there has to be an answer that moves away from an, quote, innocent person innocently becoming a terrorist.
So you say that there has to be knowledge that this is the emblem of a proscribed organisation?
Certainly, and or knowledge that it will create the effect, because of course it doesn't have to be the emblem of a prescribed organisation, it is the effect upon the reasonable bystander. So perhaps knowledge that it would tend to have that effect in the formulation I just suggested to my Lord.
Have the effect of being taken by a bystander to be the symbol of a proscribed organisation?
Yes.
And then if you turn it up a notch or two, requirement of an intention to show support for a proscribed organisation.
Well, the test in the section is not showing support, it is giving the public the impression support is being shown. That obviously is a distinction, and that's the clear language. Therefore, we do not contend that it should simply be knowingly showing support, because that's a different section anyway. And although Parliament frequently has overlapping sections, it would not make sense, with great respect, to interpret two sections as having an identical effect. That is why the formulation we suggest would be to insert the word knowingly before arouse reasonable suspicion.
And you have various alternatives, and are you going to at some point to develop those alternatives, or are you content to put it on the primary case?
We put our primary case on that basis, my lord, but our broad proposition remains, forgive me, I've said it a number of times, and I don't think repeating it helps, but I will one more time.
Well, it would help me, so just say again, where is the implied mens rea, and what does it?
My lady, in essence, forgive me, I'm sorry, I didn't mean to speak across the court. My lady, in essence, it is saying that the arousal of reasonable suspicion through the conduct, the display, or whatever, that the person appreciates their behaviour might have that effect. Now, that is not drafted in the language of a criminal statute. That is an attempt to explain the point we advance. And it seems to us the most economical way, having reflected and discussed this amongst ourselves, would be to put the word knowingly before arouse reasonable suspicion.
Does that mean that you would need to prove that this person knows, on our facts, that the PKK is a prescribed organisation?
Yes, it would, my lord.
Because you couldn't otherwise satisfy your test, I don't think.
That's true.
And then that seems to go quite a long way, doesn't it? Because somebody's going to turn round and say, well, I'm aware of the PKK, would be one argument, but I'd no idea they were a prescribed organisation.
Well,
because I don't know the law. I don't know the law. I mean, who of us knows which are the prescribed organisations? It seems an easy get-out, doesn't it, if you've got to show that?
Well, my lord, we have two answers, great respect. One is on the facts of this case. I think it's, I'm not sure if he's a professor, but Mr. Stevens, who gave expert evidence, said people on this demonstration generally would know which organisation is which and would have a perception of the law and the restrictions on that. Secondly, on the facts of these cases, the police at one stage say very loudly, before arresting, to be fair, you should not be waving signs of the PKK, they are prescribed. Now, that's not a very legalistic answer, but it may be a practical answer in the context of this case. And thirdly, I go back to the passage, I think, from Sweet and Parsley that says there's always a temptation to say, well, if we give this defence, we'll never convict anyone of anything very serious, whereas in fact, one has to allow that juries in other cases are capable of being suitably sceptical, and in this particular case, magistrates are certainly capable of being suitably sceptical about people saying, I had no idea of this, I had no idea of that. So yes, it would be a significant increase in the matters that had to be proved before people could be convicted of a terrorist offence, my lord, yes.
But if you set to one side the particular facts of this case for the moment, I think you are saying that ignorance of the law would be a defence.
My lord, yes. Well, ignorance of prescription, but yes, that is a legal mechanism. My lord's entirely right. Yes.
Just going back to your example of someone who doesn't speak English, picking up a placard. I suppose whether they were guilty would depend on what knowledge is attributed to the bystander whose reasonable suspicion is being aroused. You have to arouse reasonable suspicion in someone, and then the question is, well, what does that somebody, what are they treated as knowing about the person who is carrying the placard. If they're treated as knowing that that person doesn't speak English, then that may mean that it's not being carried in such circumstances as to arouse.
My lady, entirely so. And these examples were debated, my lady won't be surprised to hear, in the divisional court. Our simple answer to that proposition is the reasonable bystander is meant to be reasonable. They're not meant to be a mind reader. A reasonable bystander seeing 10 people holding a placard will not be able to know that 2 of them can't read English.
So you say one wouldn't attribute such characteristics of the defendant. You wouldn't attribute to the bystander any knowledge of the particular circumstances of the defendant.
Only those that are readily observable or readily audible, perhaps. And my lady, that would be, with great respect, another mechanism to avoid accidental convictions for terrorism. If one says the reasonable bystander should be acquainted with all the personal characteristics of the person holding the placard. That may be, legally speaking, a rather long way around the houses of great respect, but nonetheless, we say that could be a mechanism. Can I move on, if I may?
Sorry, just before we leave that, so that's an alternative to using a mens rea approach, that you actually clarify the actus reus in terms of the reasonable suspicion. You're suggesting that the reasonable suspicion, another way of looking at dealing with the issue, is clarifying the factors that would go into reasonable suspicion, so that, for example, if the person carrying the flag was blind, that knowledge of blindness would be attributed to the in working out whether there was reasonable suspicion. Is that the point?
Well, it would be another way of resolving the problem, my lord, but one does get to a position where a person on the Clapham omnibus has second sight. Forgive me, that's a clumsy example, given the example my lord gives. But a person can know everything about someone by observing them, whereas as the thrust of the Act, as we have understood it, is someone standing at the side, seeing a demonstration walk past, what they will make of it from what they observe. But yes, if we have a heightened state of knowledge of the reasonable person, that would be an alternative mechanism. We say it's done much more simply by putting the word knowingly into the existing words of the section.
Thank you.
Can I just ask, is the offence what one would call a result offence? Namely, you have got to produce reasonable suspicion.
Yes, my lady, it is a result offence, and of course the case the divisional court referred to is Norman, forgive me,
Yeah.
Harkin and Norman, I'm great,
Yes.
Which is a result offence. But my lady, our simple answer to that is lots of offences are result offences. Indeed, well, the majority of criminal offences are the result offence. One thinks of public order light to cause a fear of violence. One thinks of murder or some forms of manslaughter, but that is not to say that the person at risk of conviction has to have a mental element before they are convicted on the basis their conduct leads to a certain result.
It is quite noticeable that he doesn't have to be carrying an article, which is a PKK flag. Anything will do.
My lady, yes. Can I try to move on to the end of this first argument? I'm sorry, forgive me.
No, I'm conscious of the fact that you have limited time and
yes.
you still have to deal with Article 10.
Yes. Well, this touches upon Article 10 because there is one aspect of Article 10 and European jurisprudence and the jurisprudence of this court's about understanding the Convention, which we say touches on mens rea. There's also a completely freestanding argument. And it's this. And it arises because, of course, the qualification of Article 10 introduces the European Court's concept of legality, of certainty, as does the common law indeed, and we give examples of that in our written argument. Perhaps we can just look at a recent description of what legality amounts to, though the court will be very familiar. Can we go very briefly to, I think, Lord Sumption's judgment in the case of Gallagher? It's page 809 in the electronic system, and it is divider 25, please, in our hard copies. So 809 electronically, and it's divider 25, which we then pick up, if we may, internal numbering 227, electronic 809. It's the judgment of Lord Sumption. It's at paragraph 19. It's a decision, of course, of this court, being Lord Sumption. I suppose it could be the Privy Council as well. At paragraph 19, Lord Sumption recites the perhaps well-known provisions of the Sunday Times and United Kingdom, Strasbourg Court talking about legality, and summarises paragraph 49 of the Sunday Times, paragraph 19 of this particular case. A norm cannot be regarded as a law unless it is formulated with sufficient precision to enable the citizen to regulate his conduct. He must be able, if need be with appropriate advice, to foresee to a degree that is reasonable in the circumstances the consequences which a given action may entail. Now, we suggest, with great respect, a further reason beyond constitutional principles of the interpretation of statutes, a further reason to impose a mental element for this offence is that how is a citizen to regulate his conduct if he can end up with a conviction for terrorism without realising he's done anything wrong? Now, I take this shortly because I'm anxious to have some time to spend on our second argument. I take this shortly. The respondent's reply, as accepted and adopted by the Divisional Court, is the decision in Mohammed. That is page 493, electronic 493, please, divider 6. And it is a decision of the Court of Appeal given by Lord Justice Dyson, as he then was. And forgive me, the Court has written submissions and the judgments, and I'm anxious to get on to our second argument, so may I simply summarise it. In the context of Mohammed, Lord Justice Dyson dismisses an argument about legality on the basis, well, it's legal certainty, not factual certainty, because in the context of Mohammed, he knew full well he was gambling. He may or may not have known he was at risk of bankruptcy, and it was an offence, arguably a regulatory offence, to recklessly risk money at the risk of your creditors being deprived of money when you were eventually made bankrupt. Now, in the context of that, Lord Justice Dyson said, well, of course there are uncertainties. Mr. Mohammed may not have known he was going to be made bankrupt, but the law is perfectly clear, and that is what the concept requires. Well, we say that is completely different. And again, with great respect, it shows the danger of a sentence in a judgment, however distinguished the tribunal, being taken as a statute that applies to all circumstances. We say on the facts of this case, legality should mean you cannot have an accidental terrorist. Can I then move to our second argument, which is this? Which is that there should not have been a conviction under Section 13 in circumstances where the conduct complained of did not risk violence. Now, that takes us immediately to the Court of Appeal decision in Chowdhury, as relied on and approved of by the Divisional Court in our case. And could we go to that, please? It's electronic 460. Chowdhury starts. It's divider 4 in the paper version. So electronic 460, please. And just before going into parts of the judgment, forgive me, 460 electronically, please. There are things we say to have in mind before considering the judgment of Lady Justice Sharp as she then was. And they are these. This was a pre-trial appeal, so there was no factual context that had been found for the court to consider the Article 10 argument. The argument being advanced was that language which did not explicitly incite violence should be out with a prosecution for, in this case, Section 12 of the Terrorism Act, 2000. Now, that is, we suggest, a completely different circumstance to the argument we advance, because the key distinctions are, in these appellants' case, the court does have a factual context. There have been facts found. They're not in dispute. And we do not say, and it is with respect to those who advance the argument rejected by Lady Justice Sharp, we do not say there is any rule, any bright line in the terms of Chowdhury that says language which does not explicitly incite violence should be permitted, come what may. We say that the great weight, and it is a great weight, and I'm afraid we've imposed quite a lot of that weight in the bundles we've served on the court, but the great weight and the repeated weight and the consistent weight of judgments of the European Court of Human Rights is that the conduct being criminalised has to be assessed to see if it gives rise to a real risk of violence. And that is very different from saying it is the explicit words in a factual vacuum. Just to go, this was a case about...
So you say it must create a real risk?
Yes, and the precise formulation is repeated again and again by the European Court, and I will, if time permits, trouble the court with a few examples of that. But we say there's consistent jurisprudence. But it's not, forgive me, my Lord has the point, I'm sure, it's not the explicit, it's not the words themselves, it's the effect of the words. If we may, just to, I hope, make good on my factual analysis of the background of Chowdhury, if we could just go to the judgment at electronic 465, paragraph 15, please. And it's just on an important fact to understand, with great respect, I'm sure the court does already understand. This judgment, Her Ladyship says, two-thirds of the way down, paragraph 15, whilst it is accepted the talks do not contain explicit invitations to violence, the talks are said, by the prosecution, to be invitations of general support for the Islamic State and don't limit themselves to the manner in which support should be given. So that is the agreed factual basis, in far as any agreed factual basis. If we could go within Her Ladyship's judgment to electronic 469, please. Her Ladyship says at paragraph 35, and this is relevant because I will shortly attempt to persuade the court that the mere fact of prescription is not determinative when one looks at Article 10. But if we look at paragraph 35, we note that the Court of Appeal is saying that the mere fact, the fact an organisation is prescribed is not, it does not mean any approval, any considering of it being legitimate is illegal, is forbidden. Paragraph 35, it's important to note what the section does not prohibit. It is common ground, as we have said, that it does not prohibit the holding of opinions or beliefs supportive or of a prescribed organisation or the expression of those opinions or beliefs. In parenthesis, the law's now been changed so that if one expresses those beliefs, being reckless as to whether it will mean someone else supports it, it is now an offence, and the explanatory notes say it's changed because of these passages in Chowdhury. But nonetheless, it's not the case that it is completely forbidden. Just on the terms of, again, this judgment, if we go to electronic 474, please, 474. Do you have a Wingrove in hand? Yep. 474, if the court be so kind. Her Ladyship makes the point at paragraph 62, though the issue is approached in a number of different ways, the essential argument in relation to convention rights seemed to us to be based on 2 points, legality and proportionality. In relation to the second of those 2 points, the argument advances that Strasbourg discloses a bright line that the criminalisation of speech infringes Article 10 unless the speech advocates or encourages violence. Again, just to make 1 or 2 points about this judgment, if I may, at paragraph 64, Her Ladyship makes the point that Lord Bingham, in the Attorney General's reference, number 4 of 2002, and again in parentheses, if I may, the AG's reference was heard jointly with the case called Sheldrake, and it is under the title of Sheldrake that authority occurs in our bundles. So I'm not going to take the court to it unless the court will want me to. But Her Ladyship draws comfort, as it were, over the page, please, at 65, in the speech of Lord Bingham in Sheldrake, in the AG's reference part of Sheldrake. At 65, Her Ladyship quotes Lord Bingham, who at paragraph 54, talking about a different section but the same issue, of the Terrorism Act 2000 and Article 10 of the Convention, and that passage quoted from Lord Bingham in AG's reference finishes, "I'll be inclined to hold subsection 1 proportionate for Article 10 purposes." Then he talks about the legal burden, is what Sheldrake was about. Well, that has this health warning with respect. If one looks at the actual judgment in Sheldrake and Attorney General's reference, the next sentence Lord Bingham adds is, I paraphrase no doubt without his elegance of expression, but I'm not going to decide it this time anyway because it doesn't arise. And the other point is, Lord Bingham was not, of course, considering a specific body of determined facts. He was considering the argument advanced in Chowdhury, which is in abstract, without any factual basis. It was said Article 10 would forbid the criminalisation of speech that doesn't actually demand violence. Again, to the same effect, with respect to 72 in this judgment, at page 476, paragraph 72, Her Ladyship makes the point, Convention issues on proportionality are normally raised by reference to the detailed underlying facts. The argument for the defendants were not addressed to us in this way. The only specific fact relied on is the Crown's acceptance set out above, that the invitations of support relied on by the Crown did not contain explicit invitations to violence. And that, we say, with great respect, shows why Chowdhury does not apply to a case such as this, because if one looks at the Strasbourg jurisprudence, as I still think I have a little time to do, we do say on each occasion the European Court looks intensively at the facts and whether there was a danger of violence. It is not making rulings in the sort of factual vacuum that was being advanced in this case. Finally, before leaving Chowdhury, for my purposes at least, if the court will go to page 480, what's the reference for Wingrove? Do you know offhand? The court will go to, I do, don't we? Page 480. Again, we say with respect, this part of the judgment comes with, forgive me, a health warning is too pejorative a term. It comes with a caveat, because at 89, Her Ladyship deals with some of the cases they were taken to, including Gul and Turkey, which I'll come to, I hope, very shortly. But then at the foot of 89, Her Ladyship says, we would only add that contrary to the principle contended for, it has been held permissible in Article 10 terms to criminalise speech which does not involve any incitement to violence, albeit in rather different circumstances. The example she gives is Hoare and the United Kingdom and Wingrove and the United Kingdom. 1996, 24, EHRR, page 1. Now, we have troubled the court. I hope we've troubled the court. It may be it's still on its way to troubling the court with 2 or 3 additional authorities. And I'm sorry to do this, but can I simply give the reference of the law reports mentioned by Her Ladyship at paragraph 89. Wingrove is fully reported. We have sent that electronically. Wingrove was an obscenity case, and in finding that the banning of an obscene piece of art which caused great offence to certain religious communities.
Is it blasphemy or obscenity?
Blasphemy, I'm sorry. Yes. Well, it was blasphemy because it was fairly obscene, but yes, it's a blasphemy case. In the blasphemy case, I'm grateful, of Wingrove, the court did say it was the banning of a particular aspect was compatible with Article 10, but the court said in terms, and it's at paragraph 58, I'm grateful. Can I simply read what we say as the sentence? And then I hope that saves the court. It's electronic, thank you, 48 in the new mini bundle, so it's not in the...
But I don't think the new bundle's reached us yet.
Well, I apologise. We've done our best, and I'm sure the fault is mine on these occasions.
Supplemental bundle at page?
Page electronic 48.
Thank you.
It is paragraph 58 in the case of Wingrove, and it says this: whereas there is little scope under Article 10.2 of the Convention for restrictions on political speech or on debate of questions of public interest, a wider margin of appreciation is generally available to contracting states when regulating freedom of expression in relation to matters liable to offend intimate personal convictions within the sphere of morals or especially religion. So the court there draws a bright line between political speech, cases of political speech and argument, and the sort of case they were considering in Wingrove, which we do say means that the reliance, insofar as there is reliance within Chowdhury on the cases of Hall and Wingrove, with respect, the reliance should not be significant. We would like to almost conclude by going to 3 or 4 of the European cases. But may I start this section, or the second part of our argument, by considering with the court the fact of proscription, because obviously a very significant factor, we would say at times it almost reads like the determining factor of the decision of the Divisional Court, and a factor heavily and entirely properly relied on by the respondent is the fact the PKK is proscribed. Well, we say there are 3 reasons or groups of reasons why the court should approach that with some caution. That is not to say prescription is irrelevant. Of course, we don't put it that high, but we do say prescription is not, as it were, the silver bullet that deals with all objections. And we say that for 3 reasons. The first reason is the mechanism, the machinery of prescription sets an extraordinarily low hurdle and an extraordinarily high hurdle for any challenges. And could I remind the court of the terms of the Terrorism Act 2000 on this topic, please? And they are at page 277 of the electronic bundle, tab 1 in the paper one. 277, please. And that is section 1 of the Terrorism Act 2000. It is, my ladies, my lord, an extraordinarily wide definition. It's the use or even just the threat of action. It's to influence a government, and it's to advance a political, religious, racial, or ideological cause. The types of action which fall within terrorism are involving serious violence, serious damage to property, endangering a life other than suicide, creating a serious risk to health or safety, or to interfere with an electronic system. The terms of the proscription process is at Section 3 of the 2000 Act, electronic 280, please, page 280. Building upon the very wide description of terrorism, and just in passing, we would point out that this court, in the case of Gul, as opposed to the European Court of Gul, case of Gul, expressed concern, I hope is not a controversial term, expressed concern in the Supreme Court case of Gul about the width of the definition of terrorism, including groups to whom the British public had great sympathy, and including virtually any group who even threatened damage anywhere. The terms of prescription at Section 3, please. The Secretary of State, it's subsection 3. The Secretary of State may order to add an organisation, etc. Subsection 4. The Secretary of State may exercise, in fact, her power under subsection 3 in respect of an organisation only if she believes it is concerned in terrorism. So it's, of course, it has to be rationally based, but is nonetheless the belief of the Home Secretary. And then if we look for what concerned in terrorism means, it is even wider than the Section 1 definition, because below that, subsection 5, for the purposes of subsection 4, an organisation is concerned in terrorism if it commits or participates in acts of terrorism, prepares for terrorism, promotes or encourages terrorism, or is otherwise concerned in terrorism. So subsection 5, subsection D, allows the fact the Home Secretary to form the view an organisation should be proscribed if it doesn't commit or participate, prepare, promote or encourage, but in some other way is concerned. Again, merely in passing, we note that in the case of Zafar, the Lord Chief Justice, Lord Phillips, as he then was, thought the term concerned was so remote and diffuse that Section 57 of the 2000 Act should be read without it. His Lordship simply expressed that as a lack of certainty, and perhaps that was a running together of the European Court's concept of certainty and the English common law concept of certainty. But anyway, so it's extraordinarily wide, my ladies, my lords. The Home Secretary manifestly does not need to find there is any danger in the United Kingdom. She does not need to find there is any timing aspect. There does not have to be immediate danger. She does not have to say the organisation is immediately and this very month, as it were, engaging in terrorism or concerned with terrorism. It is extraordinarily wide. Of course, there is a power of review. There is, perhaps not elegant word, Section 4D proscription. One can apply. Section 5, if the Home Secretary declines to deproscribe, there can be an appeal to the Commission, but Section 5, forgive me, electronic 285, please. The Commission, in considering an appeal against the Home Secretary's refusal to deproscribe, will apply judicial review, a test of as on judicial review. So, of course, because we're in convention country, there may be close and anxious scrutiny, but nonetheless, we have an extraordinarily wide definition of terrorism. We have an extraordinarily wide connection, distant connection to that definition. We have the subjective belief of the Home Secretary, and then we have an appeal mechanism on judicial review grounds. The second point we make about why, my clumsy phrase no doubt, prescription is not a silver bullet for the respondent, is that, in fact, there are residual bits of liberties, as described in Chowdhury, where people still are allowed to approve of a prescribed organisation. They have to be fairly careful how you express that approval because of the battery of criminal offences. And if people are campaigning to deproscribe an organisation, there is a protection from them being prosecuted under Section 13. This is Section 10 of the 2000 Act, page 296, electronically. Anything done in relation to an application to deprescribe shall not be admissible as evidence in proceedings for an offence under, inter alia, section 13. So it would appear, if someone is applying to the Home Secretary to deprescribe, if one adds the word deprescribe before the words PKK on one's banner or flag, it would seem that is a lawful activity on the face of section 10. Well, not lawful, it is an activity immune from use under section 13. So, forgive me, the point we make is, firstly, it's an extraordinarily wide test. Secondly, there are still a number of activities that can engage. So, for example, the Divisional Court said the mischief one of the mischiefs was that people seeing this protest might think the PKK are a legitimate organisation. Well, it seems to us, with great respect, one is allowed to think the PKK are a legitimate organisation as long as one doesn't express, etc., all the sections. And the third point is this, and perhaps the point overall, is that in case after case, the European Court of Human Rights has dealt with the prosecution of people, often in Turkey, often linked to the Kurdish groups, in fact, but that's perhaps by the way. Again and again, the European Court has said that people being prosecuted for activities for proscribed organisations may yet be a violation of Article 10. So we do say prescription is not really a silver bullet. Can I take the court, if not finally then penultimately, to a few of those decisions? They are described at great length in our written case. There are decisions that fall both sides of the line, but the European Court applies, we would say, a consistent approach which requires the action to risk bringing about violence. May I deal with one aspect? The Respondent and the Divisional Court rely on the fact that the European Court of Human Rights also normally includes a mention that severity of sanction is a relevant matter and whether the interference with Article 10 has been disproportionate. And of course, in this case, the Respondent, as they are quite entitled, rely heavily on that, because the Respondent's case is, well, the appellants in this case did not receive, they certainly weren't imprisoned, that they could have been, but they did not receive any particularly harsh sanction, to which our answer is, the risk of leaking back the first argument, no, but they have a terrorism conviction. But I digress, and that probably isn't helpful when I'm trying to get our second argument done within the timescale. So, yes, but it's always a sub-note. We would say there are no cases, amongst the many examples of the European Court of Human Rights, there are no cases where the court says, well, the activities prosecuted here did not risk violence, but the punishment was very slight, so it's compatible with Article 10. It is always, as it were, a sub-note. I would like to take the court to a...
Just before you do that, if I may, can I just be clear as to how this argument about Article 10 fits with your first argument about mens rea?
My Lord, sorry.
Well, sorry, I won't go on.
My Lord, in this way, Article 10's only relevance to mens rea is the point about legality and predictability of conduct, as in Gallagher, as dealt with or not, depending on one's view in Mohammed. This is a freestanding argument. If the court were against us and thinks there is a compelling history of the legislation or whatever, forgive me, if the court was against us by some route and thought there need not be a mens rea, we would say, nonetheless, the actions of these appellants in this particular case was so utterly distant from provoking any violence anywhere in the world that their prosecution is nonetheless offensive to Article 10. And the obvious resolution to that is to allow these appeals.
Right, so it's not an argument that in a sense, through Article 10, you also need to read words in
only
to the offence?
No, it's not. Forgive me, only in the limited way I've attempted to touch upon legality. And my Lord...
But just to follow on from that, I mean, a lot of the arguments you've had about the width of this would apply even if there was mens rea required. But I thought you were saying that this second argument only you only raise this argument if we're against you on the first point. Obviously, you only need to raise it if we're against you on the first point. But do you say that there's an Article 10 problem with legality and predictability, regardless of whether there's a mens rea element in Section 13?
My lady, no. Predictability only attaches to the mens rea argument. Gallagher and Mohammed only attaches to the mens rea argument, though it may be our second freestanding article is linked to strength and could overlap to that extent. But, my lady, to be clear, and in fact there is a difference, and it's the sort of detail the court does not perhaps need to engage with, but if one looks at the case stated to the divisional court, it did link the Article 10 point to a lack of mens rea. I think I'm right in saying, and I'm sure be corrected by many people if I'm wrong, that the questions sent to this court are actually freestanding. The Article 10 does not link into the lack of mens rea. So, forgive me, to answer my Lord's question, I think the answer is no. They're separate. They're freestanding arguments. And if the court felt the prosecution of these three appellants violated Article 10, then there are two things the court, with great respect, could do. One is overturn their convictions, and the second is, by doing so, it would be made clear to the prosecuting authorities and the junior courts, and forgive me, they're all junior courts, of course, from this court, that people should not be prosecuted. This section should not be used where the activity complained of did not lead to a real risk of violence. I'm sorry, my lady.
In the case stated, para 26, the second question is dependent on the offence being one of strict liability.
Um,
158.
I'm so sorry. That was certainly I'm sorry, my lady. I didn't mean to interrupt. Forgive me.
No, you didn't at all.
That was certainly the issue sent to the divisional court. My memory is that the questions before this court actually exclude that the opening words of the second question so as to allow them to be freestanding.
Well, actually, it says if so.
And, well, my lady, if I am wrong, and
I'm sure you're much more familiar with this than me, but I was looking at 127.
well, I'm looking at page 70, forgive me, and my lady may well be more familiar with parts of this case than I am, though I've done my best. If one looks at page 70, please, electronic 70, it is the end of the statement of facts and issues at paragraph 18. And at 18.2, were the appellant's convictions for offence under Section 13 compatible with Article 10?
I mean, I understand they're self-standing points, but in fact, the High Court's order, sorry, the Divisional Court's order does use the words "if so" as predicating, as prefacing the second question. So they thought they were. I'm sorry, their certificate says.
My lady's entirely right, entirely right. The best I can do, perhaps, is retreat to the fact this court is free to rewrite the questions. Pendleton, paragraph 1, is an obvious example to those of us who grew up in the criminal field. The court said, well, that may be the question, but this is the answer we think justice requires us to give.
But they are interlinked in that if there is a requirement of mens rea, and there's also a requirement, you say, that the activity leads to or creates a real risk of violence, then there's a question, does the mens rea also apply to the creation of the real risk of violence? Do you have to know not only that you might arouse a reasonable suspicion that you're supporting a prescribed organisation, but you also have to know that you might also be creating a real risk of violence?
Well, my lady, that is a complication that I confess I have not applied my mind to. I'm also conscious I have half an hour at the end of today to reply. Would my lady be content for me to seek wiser counsel such as Mr. Bunting and engage with that later on. I'm sorry, that's not meant to be dismissive. It's simply I'm conscious I have a few cases left I'd like to take the court to.
But I suppose, sorry, the problem that's still running through my mind is, are you raising an Article 10 point even if there is mens rea?
Yes. Because none of the cases, well, and the law, we would say, supports that, because we wouldn't need to win the appeal. But, my Lord, if one looks at the Article 10 cases, none of them are accidental publication or speeches or demonstrations. They are all conscious acts. Now, whether the offences in Turkey normally have a mens rea or not, as I stand here, I confess I don't know. But it may... sorry.
And what do we then do under the Human Rights Act?
Well,
do we declare that this is incompatible? Is that what you're asking for, or do we read something in under Section 3 rather than Section 4?
My Lord, we would say the latter for this reason, because if the violation of Article 10, as we suggest, arises not in a factual vacuum, if there could be many cases where a prosecution would not violate Article 10, then it would seem to us a great respect that a declaration of incompatibility would not be the solution. It would seem to us, again, with great respect, matter for the court, of course, that if the court were to say in a judgment of this court that on this particular occasion the prosecutions and convictions violated because of no proximity to violence, that would firstly be a basis to allow the appeals of these particular appellants, whose interests I must not lose sight of in the great scheme of the future of the law, and secondly, that judgment would alert judges, prosecutors and police officers at a peaceful political demonstration, even if parts of the demonstration express support for a prescribed organisation, which should not be met with the criminal law. There was, I believe I'm right in saying that the government was put on notice that one of the possibilities was a declaration at the divisional court, and I think the Attorney General was consulted and was content for the case to proceed with the very able representation available to the respondent on that occasion.
But you're not asking for a declaration of incompatibility?
No. Can I then turn to the case of Zana? It's page 538, please. It is at tab 8 of our bundle. And this is a case when the court found the prosecution of a mayor was compatible with Article 10.
Sorry, bear with us a moment, if you would, please. Yes.
Grateful. If the court will go straight to electronic 544, please. 544 within the case of Zana and Turkey. It's a European Court of Human Rights case from 1997. And one does have to have an eye on the facts because these are factually sensitive, but I will, as the court has these cases rehearsed in our written case, and as the court has the cases, I will just pick out what's seen to us with great respect to the key elements. 544, if I may, please. At the top, Mr. Zana was a former mayor of Diyarbakir. Paragraph 10 is relevant since approximately 1985, serious disturbances have raged in southeast Turkey between the security forces and members of the PKK. The lives of in excess of 4,000 civilians and nearly 4,000 members of the security forces. That's the background against which the court then considers the complaint of Mr. Zana. Paragraph 12, he was serving several prison sentences at the time in the local prison. He was interviewed and he said this: "I support the PKK National Liberation Movement. On the other hand, I'm not in favour of massacres. Anyone can make mistakes, and the PKK kill women and children by mistake." He was prosecuted The sentence he would have to serve in the end, and this is at the top of 564, please, 564. He was sentenced to 12 months imprisonment, but the regime in place, right at the top of 564, he'd have to serve 2 months and 12 days. And then the court turned to consider his application. And if we could pick it up at page 559, please, 559. And at 49, and this is the judgment, it refers back to the Commission. In the Commission's view, such a statement from a person with some political standing, a former mayor of Diyarbakir, and my lords, that is the, I think I'm right in saying, is the largest city in southeast Turkey. The authorities could reasonably lead the national authorities to fear a stepping up of terrorist activities in the country. The authorities had therefore been entitled to consider whether there was a threat to national security and public safety, and that measures were necessary to preserve the country's territorial integrity and prevent crime. The court notes that in the interview, he indicated he supported the PKK movement, and as the Commission noted, the applicant's statement coincided with the murder of civilians by PKK militants. That being so, it considers at a time when serious disturbances were raging in southeast Turkey, such a statement, coming from a political figure well known in the region, could have an impact such as to justify the national authorities taking a measure designed to maintain national security and public safety. The court then rehearses the arguments against saying this was consistent with Article 10. And if we could pick up the decision of the court, please, at paragraph 59. This is electronic 562. 562, please. The statement, that's the statement of Mayor Zana, obviously. The statement cannot be looked at in isolation. It had a special significance in the circumstances of the case, as the applicant must have realised. As the court noted earlier, the interview coincided with murderous attacks carried out by the PKK on civilians in southeast Turkey, extreme tension at material time. In those circumstances, the support given to the PKK, describing them as a national liberation movement, by the former mayor of the most important city in southeast Turkey, in an interview published in a major national daily newspaper, had to be regarded as likely to exacerbate an already explosive situation in the region. The court accordingly considers the penalty imposed on the applicant could reasonably be regarded as answering a pressing social need, and that the reasons adduced by the national authorities are relevant and sufficient, and he only served a fifth of his sentence. Having regard to all those factors and the margin of appreciation, the court considers the interference was proportionate to the legitimate aims pursued, thus no breach of Article 10. I think they do find a breach of Article 6, but perhaps that need not detain us.
So that's not saying that the actual offence is of itself contrary to Article 10. That is looking at this particular conviction.
My lady,
that's
precisely.
Different from your first ground, which is changing the nature of the offence.
My lady is entirely correct. The interpretation point would apply to all defendants, regardless of the circumstances. The second freestanding argument is that on the facts of this case, there was simply no such link. Can we look, I think I have time for two more before concluding my submissions. Can we go perhaps to the case of Surek? It's at 1694, tab 57, please. Surek, tab 57, 1694. It's a Strasbourg case from 1999. Forgive me a second. If we pick that up, if we may, at the facts of that case, and again, the court has these documents, but I hope just picking out what we say are the key facts is helpful. The court could go to 1699 electronically, please. There's two Serics. In fact, it's the same Seric in the next case as well, but this is Seric number 1. He is a publisher, I think, of a newspaper. He publishes letters, 2 readers' letters indeed. He's a major shareholder in the company that publishes. And they include comments such as, if one looks at 1699, about the bourgeois press writing about the slaughter. End of that subparagraph, the Kurdish people torn from their homes and their fatherland and nothing to lose. Below subheading B, the TC, and that refers to the Republic of Turkey, it's made clear in this report. The TC murder gang is continuing its murders on the grounds of, quote, protecting the Republic of Turkey, unquote. And on it goes. And at the top of 1700, please, 1700, the next page, in fact, the letter says, I'm addressing the faithful servants of imperialism and its hardened spokesman. The foot of 1700, the editor of the review was sentenced to 5 months imprisonment. I think the applicant's good conduct during the trial meant he was only fined 166 million of the local currency. But then the court goes on to consider Article 10. And again, forgive me, time is upon me and the court has the judgments, but if we go to page 1721, please, 1721. At 62, the court will have particular regard to the words used in the letter and to the context in which they were published. In the latter respect, it takes into account the background to cases submitted to it, particularly the problems linked to the prevention of terrorism. And then the court notes, in the first place, there's a clear intention to stigmatize the other side, using the labels of the fascist Turkey army, etc. In the view of the court, the impugned letters amount to an appeal to bloody revenge by stirring up base emotions and hardening already embedded prejudices. Furthermore, the note the letters were published in the context of the security situation in southeast Turkey. The court recites again the extent of casualties. In such a context, in such a context, the content of the letters must be seen as capable of inciting to further violence in the region by instilling a deep-seated and irrational hatred against those depicted as responsible for the alleged atrocities. Indeed, the message which is communicated to the reader is that recourse to violence is a necessary and justified measure. Now, this is a case where the court said the prosecution was compatible with Article 10, but nowhere, it seems to us, with great respect, does the court attach much significance to the fact that the PKK is, in Turkish terms, a proscribed organisation. But the court's focus in this case, and I deliberately go to 2 cases where there was no violation, the court's focus in this case is all on the potential to lead to further violence. The court does, it's fair to say, touch on the relatively, by local standards, slight punishment in finding there has been no violation. But for a last case and an example, the other side of the fence, as it were, can I go to the case of Gul and Turkey? My ladies, my lord, that is at 447 in the electronic bundle. Divider 3, for those of us still attached to such things. So 447, please. It's the European Court judgment given in 2010. The facts are at page 449, please. 449. The applicants were taking part in a demonstration in the middle of paragraph 6 for a Turkish Communist Party, Marxist-Leninist, Turkish Workers' and Peasants' Liberation Army, and the Marxist-Leninist Youth Union of Turkey. Importantly, the report adds, an armed illegal organisation. So yet again, we're on the territory of proscription. If the court would go over the page to 451, please. The various chants and the various banners include phrases such as power grows out the barrel of a gun, it's the barrel of a gun that will call to account. The foot of page 451, it specifies that the offence for which they were convicted was of an illegal organisation, in other words, a proscribed organisation. I merely summarise with the time upon me, if I may. One appellant served 3 months, the others served 10 months, albeit at one stage a longer sentence was suggested. And then if we may come to the meat of the judgment at 454, please. 454. And at 35 on 454, turning to the particular circumstances of the case, the court notes the criminal proceedings were initiated, etc., based on the fact they had shouted slogans in support of an armed illegal organisation. And the foot of that paragraph, just above paragraph 36, as to the legitimacy of the aims pursued, the court observes the authorities sought to protect national security and public order. At 37, the court sets out its task. Was the interference proportionate to the legitimate aims? Were the justifications relevant and sufficient? And at 38, the court makes, again, perhaps the obvious but entirely proper point, the court considers the above-mentioned principles also apply to measures taken by domestic authorities to maintain national security, etc., as part of the fight against terrorism. And then at page 455, what the court does is, contrary to the submissions made by the unsuccessful appellants in Chowdhury, is look at the real danger of violence, as the court has, we say, in all the cases, all the many examples. So at 41, to page 455, the court observes, taken literally, some of the slogans have a violent tone. Nevertheless, they're well-known stereotype leftist slogans. The court stressed the importance of Article 10. Then at 42, the court observes that by shouting these slogans, the applicants did not advocate violence, injury, or harm to any person. Furthermore, neither in the domestic court decisions nor in the observations of the government is there any indication there was a clear and imminent danger which required an interference, such as the lengthy criminal prosecution faced by the appellants. Below that, the court does say the sentence passed was disproportionate, but then the conclusion at 44, please. In view of the above findings, the court is of the view the applicant's conduct cannot be considered to have had an impact on national security or public order by way of encouraging the use of violence or inciting others to armed resistance or rebellion, which are essential elements to take into account. So the court's conclusion at 44 does not seem to be dependent on the sentence and the length of the proceedings. It focuses on the reasons for allowing interference with Article 10, national security, public order, and a demonstration in Turkey, a country with mass casualty violence happening from time to time. Prosecuting them was a violation because their conduct cannot be considered, etc. 45, please. Having regard to the above considerations, the court concludes that in the circumstance of the present case, the interference in question was not necessary in a democratic society. Accordingly, there had been a violation of Article 10. And if I may trespass on my learned friend Mr. Mabley's time by a further 2 minutes, can I finish for my part in simply reminding the court of the precise words of Article 10. It is at page 590 electronically. It's
reference again, please.
590, my lord.
Thank you.
It's divider 17 in the paper bundles. And Article 10 is at, well, electronic 590. Everyone has the right to freedom of expression. If I say etc., it's to be hasty, not to diminish the rights. And if we go over the page, please, to the top of 591, the exercise of these freedoms, since it carries with it duties and responsibilities, may be subject, etc., penalties prescribed by law, and then this, necessary in a democratic society, in the interests of national security, territorial integrity, or public safety, for the prevention of disorder or crime. We say with great respect, it is simple, and this case is, well, the reason the advances argument and our argument, this case is a precise illustration of where Article 10 should not bite. There is no suggestion of any violent action in the United Kingdom, unlike, for example, IS in Chowdhury. There is no suggestion of English volunteers flooding abroad to carry out terrorism elsewhere, unlike IS, the organisation in Chowdhury. There is no suggestion that the protest by these young appellants led to a counter-reaction to violence, a disturbance on the streets of London. And my ladies, my lord, I finish, subject to questions and having to do other matters. Micah, our concluding observations would be these. If in the case of Gul, in Turkey, people protesting and using language about guns for a prescribed organisation, if their prosecution is a violation of Article 10, how can it be said that this peaceful demonstration, which caused no violence, where there's no evidence of any risk of violence, how can it be that that exercise of their Article 10 rights is properly criminalised? We say with great respect, it is a clear violation, and the solution is for the court to allow these appeals. My ladies, my lord, with apologies for drifting over my time limit, unless I can try to assist any further, and subject to coming back to my lady's question about mens rea in Article 10 later on, those are our submissions.
Thank you. Thank you, Mr. Bentham. Mr. Bunting. We'll rise for a moment or two. Mr. Mabley.
My lord, my ladies, in responding to this appeal, the respondent adopts the previously served written submissions, and in summary, the respondent submits that the decision and reasoning of the divisional court were correct. There are two overarching submissions advanced by the respondent. First, it submitted that Parliament clearly intended that the offence contrary to Section 13 is committed without a requirement to prove that the accused had any particular state of mind of the kind suggested by the appellants, whether that be an intention to incite violence or to arouse a suspicion that he's a member of or supporter of a prescribed organisation or knowledge of that matter. Instead, it is sufficient to prove that the accused's conduct within the description of the offence was objectively such as to arouse a reasonable suspicion that he's a member or supporter of a prescribed organisation. The second submission is that a consideration of Article 10 does not alter that conclusion, and that Article 10 does not require that any infringement of expression in this area must be connected to an imminent risk of violence. That proposition, advanced by the appellants, is simply not borne out by the Strasbourg case law. And in that regard, the respondent relies not only on the decision of the Divisional Court, but also the decision of the Court of Appeal in the Crown and Chowdhury. Well, what I would propose to do is make submissions, first of all, in relation to Parliament's intention, and then move on to address the position under Article 10. As has already been stated, Section 13 falls within the scheme of prescription under Part 2, which is split into two headings. Sections 3 to 10 under the heading Procedure, which is the scheme by which organisations are prescribed and by which challenges can be made. And secondly, the heading Offences, and there are three offences, sections 11 to 13. May I make four general points about the scheme which frames those offences? First of all, prescription is integral to the measures Parliament has considered necessary to combat terrorism. Prescribed organisations are terrorist organisations within the meaning of that word in domestic legislation, and their activities, and indeed their very existence, risks the life and property of citizens of the United Kingdom and beyond. Secondly, the PKK is such an organisation. And notwithstanding the points which have been made this morning about the breadth of the scheme, there is no challenge to the status of the PKK in this appeal, and nor could there be. And as a matter of law, in connection with that, there is no grading or hierarchy of prescription. The categorisation is binary. Thirdly, the offences under Part 2, including Section 13, are, together with the terrorist funding provisions in Part 3, the means by which the scheme of prescription is enforced. The scheme simply has no value in the absence of the means to put it into effect. And fourthly, as the Court of Appeal recognised in Chowdhury, the offences, all of them in Part 2, are not substantive offences of terrorism. They are not offences, any of them, which involve proof either of an incitement to violence or of an imminent risk of violence. Those offences are instead designed to inhibit activities associated with terrorism. They're the means by which Parliament has sought to suppress terrorist organisations by depriving them at the root of membership, support, and the oxygen of favourable publicity and shows of strength in public. And so none of the offences involve a requirement to prove in a direct sense imminent violence. And of course, it appears to the respondent that much of what was said by my learned friend in relation to Article 10, in relation to Section 13, would apply equally to the Section 11 and the Section 12 offences, if a similar connection with violence was required in their case. And so it's in that context that Section 13 criminalises displays in public which give rise to a reasonable suspicion that the person displaying the item is a supporter of a terrorist organisation. May I next say something about the approach to the exercise of statutory interpretation and the presumption? The respondent, of course, agrees and accepts that the presumption is an important principle of criminal law. But the task in any case in this area is to ascertain Parliament's intention by reference to the statutory provision and, if necessary, other relevant matters. May I touch on the three authorities referred to by my learned friend briefly? First of all, Sweet and Parsley at electronic page 519. Dipping into the immediately the judgment of Lord Reed. At F, the final substantive paragraph on the page, Lord Reid makes the point that the court's first duty is to consider the words of the Act. And he then, towards the bottom of that paragraph, deals with the point that in some cases acts are silent in that they say nothing about blameworthiness. Over the page at 520, at C to D, Lord Reid explains the presumption when he says that it's firmly established that mens rea is an essential ingredient of every offence unless some reason can be found for holding that it's not necessary. And then at D to E, D to F, he makes the point that in the absence of a clear indication in the Act that an offence is intended to be an absolute offence, it's necessary to go outside the Act and examine all relevant circumstances. Now, with that statement in mind, Lord Nichols in B, and if I can just briefly take my ladies to B at 424. Lord Nichols explained that further. At F, again, he made the point that the starting point is the words of the Act. Then he made the point at G that if the Act is silent, then the presumption applies unless Parliament has indicated a contrary intention, either expressly or by necessary implication. And at page 427 over to 428, Lord Nichols explained something about necessary implication in a case where an act is silent on the mental element, when he said the question, therefore, is whether, although not expressly negatived.
Sorry, where are you?
I'm very sorry, at the very bottom of page 427.
427, thank you.
Where he's making the point that the provision that the court was concerned with, the House was concerned with, was silent. The question, therefore, is whether, although not expressly negatived, the need for a mental element is negatived by necessary implication. Necessary implication connotes an implication which is compellingly clear. Such an implication may be found in the language used, the nature of the offence, the mischief sought to be prevented, and any other circumstances that may assist. And what the respondent submits in this case, first of all, our primary submission is, in fact, on analysis, the plain language of the statute does expressly exclude the need for a mental element. And I'll say something about that in a moment. But secondly, even if it is held to be silent, an analysis of the section itself carries with it the necessary implication that there is no requirement to prove the mental element for which the appellants contend. So the respondent submits that the answer to the construction problem is found in the language of the section, but there are also indicators within the scheme itself and the mischief at which it is directed that also point to that conclusion.
Can you look at the sanction, the penalty, or not?
Yes, that is a factor. That is a factor, and it's a point, my lady, which I will turn to, because one of the striking things about these three offences is the huge disparity in sentence. And what the appellants are seeking is a mental ingredient that would make the defendant seriously culpable, and it would almost, perhaps not quite, but very closely align Section 13 to Section 12. Yeah. And then the position would be that someone who has committed a Section 12 offence would be liable to 14 years imprisonment, 10 years when it was originally enacted. But someone who had committed a Section 13 offence would only be liable to 6 months. And there's no coherent explanation for that, other than Section 13 is dealing with a far less serious offence. And the only reason it can be far less serious is because it doesn't involve a culpable state of mind in the same way that Section 12 or indeed Section 11 does. So may I then turn to the factors which the respondent relies on in relation to resisting learned friend's arguments. The first factor is the plain language of the provision, in the sense that it does not require proof of a mental element. And that was the first factor identified by the divisional court. Now, it's said by the appellants that that's a neutral factor, and in one sense it is, because in any case where the presumption is relied on or applies, the section will not have expressly made provision for a mental element. However, the divisional court didn't err in giving this factor weight, because it is inevitably the starting point. But more particularly, it is not the only factor in relation to the plain wording of the section. The starting point is that the plain wording does not make provision for a mental element. But it's also necessary, when examining the plain words of the section, to examine what it has made provision for. And this is the second factor which the respondent relies on, because the second factor is that the provision has made clear that it is concerned not with criminalising conduct coupled with intent, but with conduct coupled with consequence. It is, as was observed earlier, a result crime by my lady. Conduct is prohibited if it gives rise to a particular consequence, namely an objective reasonable suspicion. And as the divisional court put it, this is conduct which, of course, must take place in public under Section 13, which gives rise to the risk that others will be encouraged to support the prescribed organisation. And the divisional court cited an example of where that had previously arisen in the 1936 Public Order Act. So that the language, the plain language of the section, makes clear that what the provision is directed at is an objective consequence rather than culpability in the sense of an intentional or knowledge. Of course, the focus could have been different, because Parliament could have criminalised conduct plus the person's intent, and that would have been a sufficient basis for liability. If that was the basis for liability, the objective consequence would be irrelevant. There'd be no need for the section to refer to it. It would simply be a person in a public place commits an offence if he, A or B, with intent to arouse suspicion that he's a member or supporter. And that would be a perfectly coherent way of constructing an offence. But what's not coherent is to import an ingredient of knowledge between the word as and to. Knowledge would always be inapt in conjunction with an objective consequence, because a person can't know if an objective consequence is going to arise or not. But if intention is required, then it may be asked, why would the objective consequence be relevant at all? If the person intended a particular outcome, it wouldn't be necessary, presumably, to go on to prove that that outcome actually arose. And the submission that was advanced this morning as to, well, what is the appropriate mental element, what did Parliament intend, appeared to be somewhat protean. But as was observed, that the task here is not, as Lord Hughes observed at paragraph 9 of Letson Lane, to ask a court to intervene and mitigate something that Parliament has done. The task is actually to identify what Parliament's intention was, and it must have been a single intention, and it must have been coherent within the words which Parliament has actually drafted. And the submission that the respondents makes is that there isn't thus far a coherent alternative in relation to a mental element that would actually fit within the last part of this section. Because if a person's intent was relevant, then the way in which he was carrying the flag or the circumstances in which he was carrying the flag would be irrelevant to proof of any offence. So what the respondent submits in relation...
Can I just stop you for 1 minute there, if I may? I understand the point about intent, but I think the primary way it was being put this morning was on knowledge. And I'm not sure that at the moment I quite see why your proposition that knowledge is something that cannot be combined with an objective result is somehow, I don't know, conceptually impossible. I'm not seeing that.
Well, it's very difficult to prove that someone will know that something will happen. Now, it's obviously easy to prove that someone may intend a particular result, but if the prosecution were required to prove that the accused must know that his conduct would in fact result in a particular outcome, objectively speaking, it appears to the respondent that would be, first of all, very difficult to prove, and secondly, a curious requirement. Why would the knowledge be a factor that Parliament would wish to penalise?
Yes, thank you.
With regard to a future event, your point is that you would expect the statutory language to say that there was an intention to bring about that event.
Exactly.
Whereas knowingly doesn't really fit.
Exactly, and the accused can't himself know what the objective bias to examine his knowledge. You'd have to import into his mind all kinds of factors that would be relevant to an objective assessment that he could never know.
Intention plus the actual occurrence of the result. You could say it's an offence for you to intend to arouse suspicion and for suspicion actually to be aroused. That's not an incoherent one, particularly because you could have an attempt to do it, presumably.
Yes, but that would not be an objective. It would no longer be objective. It would be the subjective intent
Yes.
plus the result actually occurring, which doesn't fit in with what Parliament has actually drafted. And in those circumstances, of course, the way in which the flag was waved in this case, or the circumstances in which it was waved, would be irrelevant. They would be factual matters that would be important to examine in any trial, but it wouldn't be necessary for the wording of the section to focus on the way that it was waved or the circumstances in which the article was displayed. So the point that the respondent makes is what's dealt with in the last part of section 13 is an objective test. That's what Parliament has set up, and an objective test is inconsistent with importing a subjective element into that stage of the offence.
I suppose it wouldn't be if you changed it. I mean, I'm not now suggesting that this is being put forward, but if we're trying to think of what might have been a possible mens rea, would something like foresee be compatible?
I'm sorry?
Foresee, in such circumstances that the defendant foresees.
That's, I suppose, one down from knowledge.
Yeah.
Or is reckless as to whether a reasonable suspicion is aroused. Yeah.
I mean, you know, it may not be for you to actually. I mean, these aren't submissions that have been made against you, but I mean, are you saying that there is no mental element that is conceivable in relation to the words arousing reasonable suspicion?
Yes, there are two submissions. One, there's none which is tenable, I would say.
None
which is tenable.
I'm asking about possible.
Well, it's plainly possible in the sense that if it's there, it would linguistically make sense, but it would not be.
All right,
it would not be coherent. It would not be coherent, is my submission.
Right. Okay. Yeah. Thank you.
I think I'm sort of envisaging this clause going through Parliament, and somebody stands up and says to the minister who's promoting it, well, this looks a bit tough. There's no mental element here. It looks as if you're creating a strict liability offence. And the minister says, no, that's not what we're doing, because the courts know very well that there's a presumption of mens rea, so we don't have to put it in because the courts will know that it's supposed to be there because of all this case law. And I think what we're exploring is that a sensible scenario, or does one then say, but the trouble is it's not at all clear how the presumption is supposed to apply, what and where the mental element is to be interposed in the wording. And I think you're saying, well, that indicates that wasn't actually, Parliament wasn't leaving it to us to insert a mental element because it's not at all clear what that mental element is.
Well, yes, that is my submission, and it's not, the reason it's not clear is because perhaps there are several possibilities, but more particularly, once Parliament has legislated for an objective test, it makes it very difficult to insert a subjective element whilst keeping the objective test at the same time. And what the respondent says is that analysis shows that, in fact, the plain language of this section expressly ousts the requirement or any argument that a mental element is required. But to put it another way, if it is viewed as silent on the matter, then the same points carry with it the necessary implication that there is no requirement for mens rea. I've gone. It's 1:05.
If that's a convenient moment, we'll rise now. We'll sit again at 2 o'clock.
Thank you.